Kita buat dua bahasa ke satu bahasa? I have got instructions daripada Datuk Seri Najib to file an action for contempt of court against the former Attorney General, who is now Tan Sri Terrirudin, who now sits in the federal court. This contempt action will be filed, we think, by tomorrow, latest by Friday. The papers are ready, but we want to go through it carefully. That's number one. Okay? Number two, with regards to the addendum, which the due date is the 6th of March for them to reply by way of affidavit. Although they promised that they will reply within a week of last week, but nothing has been filed by the Attorney General's chambers yet. But they have got their right to file until the 6th. Yeah? They have got until the 6th to file. Now, the next one is the gag order, which was applied for by the Attorney General in the addendum case. And that was filed on the 20th of January 25. We have replied on the 5th of February 2025. Both of these are awaiting dates for us to argue. One is on the substantive matter in the addendum. The other is on the application of the gag order. That's it. Any questions? Ada apa soalan? Well, the contempt, as you know, is because we now know from the Prime Minister's statement that the addendum was received by the Attorney General, the former Attorney General. He then somehow had handed over that addendum to the current Yang di-Pertuan Agong. Okay? We are saying that is wrong because the addendum is already a decree of a Yang di-Pertuan Agong. The next thing to do is to just enforce the addendum rather than to pass it around to the next, the Yang di-Pertuan Agong. Because what would the next Yang di-Pertuan Agong do? He can't be the enforcer of the addendum. Number two is because we feel that it is not candid or honest on the part of the former Attorney General, because when we appeared before the High Court Judge, Justice Amarjit, there was total silence. In fact, they challenged us by saying that proof that the addendum actually exists. Otherwise, it is hearsay. So you imagine, if you have the addendum, you have seen the addendum, you can't be instructing your officers to say that you object because there is no proof that addendum exists. Because we're not talking about a normal litigant. We're talking about the Attorney General, the former Attorney General, who actually is a fountain of justice. And when it comes to judicial review, there is a duty of candor, they call it, duty of candor, because judicial review, apart from everything else, is also a mechanism of investigation, because this is to make government accountable. So when we file making an allegation, the government must be stating things in total candidness and candor. They cannot play hide and seek. They cannot say you prove. If you cannot prove, I won't do it, because you're not an ordinary litigant. You are the government itself. So in view of that, we're saying there is contempt. And then we will serve it on him, and then it is up to him to enter and defend himself or through somebody else. We have, by the way, issued him with the show cause letter much earlier. He has replied saying that he is denying that he's guilty. And he reiterated the position that it was only a leave stage. He doesn't have a duty to disclose. Okay? So that makes it, as far as I'm concerned, worse position.